Welcome to our immigration podcast. We do all things U.S. immigration once a week just to keep you guys up to date so you know what's going on. All right, this week we got about 4 stories for you. We're going to talk quickly about the Biden administration and their program for the Haitian parole program. They've revitalized that program. We're also going to hit the H1b visa, which has some new numbers on it. Cover a couple more topics for you, including the COVID-19 travel restriction, which is gone, and follow up with some news stories of our own, some successes at the office, as well as questions from you guys. All right, let's get it going right now with the very first story, the H1b program. So the H1b program is seasonal agricultural and non-agricultural workers. H1b itself is specifically non-agricultural. And the U.S. announced that they will be increasing the numbers for the coming lottery up about 11,000 to 35,000 cap in total. Now, this separate set of numbers is actually for employers who are going to suffer irreparable harm if they do not get the temporary workers that they originally applied for. So it's this kind of patch adding on more numbers, and mind you, these are numbers of individuals from Central and North America to come to work in the United States temporarily on the H1b visa, which is usually 9 months, and it will only be for employers in this specific group. If you got a question about it, you might want to talk to your attorney or give us a call. The H1b program continues to expand. We're seeing a lot of growth because there's a high demand for different kinds of labor. At this point, the new numbers were just announced, and we'll see how that goes into effect on the next lottery, which is coming up on this second half of the year. The Biden administration announced that they'll be revitalizing a specific program, and this program is called the Family Reunification Parole Program, the Haitian Family Reunification Parole Program. Now, this program is pretty specific, and it's actually a huge benefit to anybody from Haiti who has filed a case on behalf of a family member overseas. Under this program, if that person, meaning that person waiting in Haiti for their green card process, which is going through a family member, qualifies, they can come to the United States on a parole where they can enter, live and work in the United States, and wait here for their green card process to be completed. Now, the Haitian Refugee Family Reunification Program, HFRP, is being revitalized and kickstarted again. It's been in effect since 2014. This is a new version of it. And you're going to have to see who qualifies. You're going to have the petition already filed from a U.S. family member, and that same U.S. family member is going to have to be petitioning or saying, I want to bring them on board here to live and work in the United States. So the HFPRP, Haitian Family Reunification Parole Program, is open for business again. Check it out. If you got a question, leave us a comment or give us a call. Okay, we get a lot of questions about recession, changing jobs, and what's out there for people who are working in some sort of status, foreign nationals working in some sort of status in the United States. So let's take a look at what exists. Now, number one, if you're going to change jobs and you're an H1b, that is the overall best to be in. An H1b change of employer is allowing the new job, meaning you file your paperwork, you say, I have an H1b now, and I'm changing to a new employer, and I want to begin working at them now. That will give you an automatic permission to work at the new employer for 240 days, and in fact, that's the old rule. It's even longer than that now. If you file a case to change employers in H1b, you can jump ship and move right away. Other visas are going to need to look at the premium processing because you don't get what H1b gets, which is an automatic permission to work at the new employer. You have to actually get an approval before you start working. So this is very, very important. Recession times, job shopping, people are out there looking for jobs. You need to actually get approved for your new job if you are not on an H1b. Now, of course, the best of all worlds would be to have an EAD, an employment authorization document. There are individuals out there with H1Bs and EADs. There's people out there with just an EAD. An EAD is not tied to a specific employer unless you're on OPT. All right, so it's very, very clear here. If you have an EAD with employment authorization document and you've got it because you have a green card pending or for other reasons, you're allowed to go ahead and move that. Doctor recipients are a good example. You can move to a new employer whenever you like. There's no paperwork required. Your EAD is for a time period that lets you go work. Unfortunately, with OPT and STEM OPT, a lot of times the schools are tracking that employment and they're putting it into SEVIS. I know in STEM OPT, it's actually a requirement that the new employer do a full new training plan and explain how they're going to hire you. So EADs, very, very flexible to move employment. STEM, OPT, and post-completion OPT, changing employers, a little bit different, and you have to check with your DSO. All right, guys, hope that helps you out there. Okay, in case you haven't heard it, the United States has lifted the travel ban for COVID-19. Now, this was the travel ban that was put into place about getting on a plane and coming to the United States. You had to have a COVID-19 negative test result, or you need to have your vaccine card. They have thrown that out, and it's no longer required. In fact, that happened, I believe, at some point June 12th. Okay, it was announced in May, and June 12th it went into effect. Keep in mind that there's still, the CDC still has a order requiring proof of vaccination for non-citizen immigrants to travel to the United States. So this is kind of weird because it used to be to get on a plane, you need to show the carrier either a COVID-19 negative or the vaccination. And at this point, the CDC still has something about that. So check your guidance, check with your airline, because you want to be able to get on that airplane. And if you bring all your paperwork, it might be the best thing for you, okay? Got some conflicting rules that are still in effect. We get lots of questions about timelines, and I've got a great story for you. We just got approval in the other day, and it was a change of status from J1 to F1. We filed it, I believe, in March, and we got an RFE, and we got it approved. So we're looking at about 4 months turnaround on a change of status from J1 to F1. The RFE they asked us for was for a new start date because our start date was immediate. We had to provide a new I-20 showing a new start date. It was for a UCLA extension program. This super fast turnaround, always exciting news for us. And to me, it's a sign that immigration is taking changes to heart, and they're moving things quick and fast, finding good cases and getting them approved. 4 months is pretty fast. I don't think we can do it for everybody, but it's great news, and I wanted you guys to know about it. All right, time for our questions and answers. These are questions you guys post on YouTube or TikTok, and we try to get the answers out to you. All right, first question is, I'm a J2 with an EAD, and my category C5 is not listed under the automatic EAD renewal on the website. Is there any other way for me to find out if I'm qualified? So there is a regulation on this that was passed, but the truth is that website is pretty accurate. It lists all the codes that USCIS has, and it talks about whether you get automatic extension. I did look, and yes, the C5 category is not included on that list. There are several that are not, and if you're not on the list, I'm going to tell you that's highly likely that you're not included, okay? So the C5 EAD category, not on the list. I'm going to tell you it's not there simply because that's the way what we look at to check everything as well, all right? Next question. Are there any options for a DACA recipient to marry a J1 visitor? All right, DACA recipients are individuals who are here and basically came here as a young person and they still live here in the United States. And essentially, you have a work permit and you're here. J1 visa holder does not, marrying a J1 visa holder is not going to give you the opportunity to really change status. Keep in mind that DACA recipients don't necessarily qualify for a change of status because they lived here unlawfully for such a long time. It could be complicated. Some people might qualify, others might not. But it means you would just get a temporary status called J1, which is less than a DACA because it ends and it's all dependent upon an 18-month program, and there might even be a return home requirement. So for a DACA recipient to marry anybody with a non-immigrant visa isn't really going to do anything for them on that visa, generally speaking. Every case might be different. You should check with an attorney. The part you do want to check on is whether you marry somebody who's a non-immigrant visa and they have a process going for a green card. If they do, that's when you got to talk to an attorney because you want to make sure you're on board as a derivative beneficiary on their perm process or their green card process. All right? Hope that helps a little bit. All right. Can you transfer an H1b before October 1st, but after you get the approval to get your H1b from your original company? I get this question every year, and it's kind of a gray area. I'm going to tell you the answer is no. The answer is no because the original employer who filed for you and got you that H1b, you never actually got into status. You just have a notice. Your status actually begins on October 1st. More importantly, it begins on October 1st when you start working for that person under the H-1B and show that you have some employment. So there have been some situations where people have been able to file change of employers or do some things, but generally speaking, it's not the best idea because you actually have an approval notice that's in the future. It's not for right now. You don't have an H-1B. You don't hold that status now. You can't say, hey, I've got an H-1B, I want to change to a new employer. You never started with the first one. All right? My best advice is to actually work. Go work for a couple of weeks, work for a month, work for 2 months, whatever it is. Get yourself that payroll, get yourself established, boom, you're ready to change employer. And as I mentioned earlier in the video, a change of employer from H-1B to a new one gives you opportunity to work right away at the new employer and gives you an unlimited time to work until you get your approval notice. All right? All right, I got one last question for you. My brother has a third-degree felony. I love that. My brother does. Sure, buddy. All right. My brother has a third-degree felony on his record for a drug conviction back in '98. He volunteered. He got a voluntary deportation. He went back to his country. Okay. Bottom line is, if you have a controlled substance violation, any drug-related crime, there's a couple ways to analyze those and a couple ways to look at them. Your brother has this conviction from 1998, and he already left. That right there tells me it's pretty much done. There's not much you can do. What you might want to look at is whether that conviction in 1998 can be cleaned up, what's called post-conviction relief, or wiped away under something like Federal First Offender Act, because that would help your brother try to come back to the United States, okay, if that conviction is actually gone. Now, if somebody's in the United States and they're still here, you would definitely want to take that case to an attorney because you want to see if there's something that was wrong with the case. Was there a constitutional error? Is there a way to overturn this conviction for the purposes of immigration? Are there other programs that offer a benefit, like deferred action or, as I said, Federal First Offender Act, which ended in June 2011? So there are things that exist that might help this individual if he's in the United States. The fact that he's gone means he has a consular process to get back in. It's going to be very, very difficult when he has a conviction in the United States, even though it's 20, 24 years old, okay? All right, that's it for today. Love it you guys check in. You made it to the end. You guys are the best. Can you share the video? Leave us a comment below. Subscribe. Give us a thumbs up. Helps us get our information out there. Stay safe. Take care. Bye.